Please be seated. The court is now back in session. I notice the prosecution is on his feet. You may proceed.
Mr. President, thank you. Mr. President, you kindly indicated before lunch that the trial chamber had determined that the document presentation on joint criminal enterprise would take place at a later stage. Can I please respectfully inquire whether the trial chamber is able to give guidance to me to pass on to my colleagues in the OCP as to whether the chamber has made a decision about the document presentation on the roles of the accused. That was the presentation where I had asked if this was to go ahead next week. The OCP was asking for it to take place at the earliest next Wednesday. We all still continue to appreciate the uncertainty about next week in terms of the health of the accused. But I wonder, Mr. President, whether the trial chamber can give us any guidance on this point, given that work is being carried out on a number of fronts concurrently today. We would very much be assisted by any guidance that you can provide at this stage. Thank you.
President, after the bench has deliberated, it is the chamber's intention that next week the chamber will set the schedule on hearing the testimony of TCW 565 on Monday. If the accused Nguyen Chi waives his presence in the hearing of that testimony. That is the first point. And regarding the document submissions on the roles of the accused, the chamber will determine the scheduling of that hearing and that will be held on Wednesday next week. However, this is tentative, depending on the health of the accused, Nguyen Chi and his defense team, And of course, we will communicate that information to all parties via email tomorrow afternoon once we receive further information regarding this matter.
Mr. President, I'm grateful. Thank you.
សូមគោរព
Mr. President, before our lunch adjournment, you mentioned about the scheduling of the document presentation on the roles of the accused and the joint criminal enterprise. And now you indicated that the document presentation regarding the roles of the accused will go ahead tomorrow, next week rather. And I'd like to inquire further what will be the tentative schedule on the document hearing regarding the joint criminal enterprise, whether it will be done after the roles of the accused document presentation. President, thank you for your inquiry. As the Chamber indicated, it is unlikely that we can proceed with the document hearing on the two facts or themes, that is the roles of the accused and the joint criminal enterprise. But after the break, we received information from the prosecution that they are able to proceed with the document presentation regarding the roles of the accused. And that they can make that presentation on Wednesday next week. So that's the new development in order to expedite the proceedings in this case. Regarding the joint criminal enterprise policy, we will not set the scheduling on this matter yet. The Chamber will decide in due course on the appropriate time for the documentation hearing on this particular fact. And of course, we will inform the parties prior to the scheduling so that you can prepare the document. So that fact is separate from the documentation presentation regarding the roles of the accused. And the document hearing on Wednesday next week is only related to the roles of the accused. I noticed the National Defense Council for Khieu Samphan on her feet. You may proceed.
Oui, merci, monsieur.
Yes, thank you, Mr. President. Good morning to everyone in the courtroom and to the parties and your honors. I would like to make sure, Mr. President, that as part of the medical information, I would like to know whether the citation of my client is also taking into account the last certificate dated the 22nd of January is the document we have in hand. It is important for us to know how to proceed next week. All I have is that medical certificate dated the 22nd of January. So I'd like to know what is the position of the Chamber regarding next week's hearings. I am not sure that my client will be able to attend next week's hearings, so I wanted to be sure that you are taking into account his health status.
President, thank you, Counsel, for the inquiry. The Chamber receives information regarding the health of the accused Khieu Samphan, and the Chamber expects that Kil Sampon will be discharged from the hospital likely by this weekend. And if he is to be continued hospitalized, the chamber will inform the parties as well, because then it's going to be contradictory to the expectation of the chamber regarding next week's scheduling. And we set that scheduling based on the information and development of the health, of his health. And the doctor expects that he may be discharged this weekend. However, we still adhere to the principle of conducting the hearing in the presence of the accused, pursuant to relevant internal rules applicable before this chamber. And if there is new development, of course, the chamber will inform all the parties. I would like now to give the floor to the defense teams, starting from Noon Chi's defense, so that you have the opportunity to comment or to express objections to the key documents presented by the prosecution and the lead co-lawyers. Those documents are related to the facts as I mentioned this morning. Additionally, regarding the documents related to the military structure as presented by the lead co-lawyers, defense teams in addition may also present further documents related to this fact as I mentioned in E223/3 paragraph 4, that is those documents related to those paragraphs accepts the roles of the accused and the joint criminal enterprise. You may proceed.
Thank you, Mr. President. Your Honours, good afternoon. As indicated earlier, we would like to give our observations and or objections by means of written submissions, and after having received instructions from our client. So no submissions at this stage. Thank you.
President, thank you, Counsel. The floor is now given to Ian Sari's defense. You may proceed.
Good morning, Mr. President. Good morning, Your Honors. Good morning to everyone good afternoon, I should say, to everyone in and around the courtroom. First, I have some preliminary remarks that shouldn't take more than a couple of minutes, and then I have approximately 5 minutes of remarks concerning the documents. I profoundly regret having to again raise my client's health, but I'm compelled to do so in light of what I've learned as of the lunch period. Dr. Kim Sam-san, who is on duty today, has indeed indicated to us, to our case manager, Mr. So Mosani, that he is not able to assess whether our client is capable of following the proceedings even when our client is awake. Today he has been mostly asleep because he was exhausted, not having slept all last night, and that can be verified with the doctor. When Mr. Mosani asked the doctor to put this in the report, that is, that he was not sufficiently competent, given his specialty, to make a medical finding as to whether our client was capable of following the proceedings, he indicated that he could not do so. He could not put that in the report unless he contacted the board and was instructed by the board as to what to put into the report, because that is what is normally done. Now, I find this rather interesting because exactly the same thing was told to us yesterday, yet in the afternoon we had a report saying that our client can follow the proceedings from downstairs. If a doctor is not in a capacity to indicate whether our client is able to follow the proceedings, how can they then make a report saying that from down there they're following the proceedings? And why would a doctor who is on call to examine our client would then need instructions from the board, which is not located in this institution, on the premises, as to what he should put in the report? In other words, it would appear, Your Honors, that you are being misled by the doctors when they say that Mr. Ingsbury can follow the proceedings. Because if a doctor is not professionally trained to make an observation, then they cannot. And such observations are nothing other than pure mendacity. Now, I understand your position. We heard from the prosecution yesterday, and we would chime in. We need to get doctors who are actually able to make such assessments. Otherwise, we should dispense with the sort of daily report, which in fact is misleading. And it's our position that our client is not capable of following the proceedings, and he hasn't waived his rights. I leave it to you, Your Honors, to decide what to do. Those are my observations concerning my client's health. With respect to the documents, I have 3 points to make. And in making these points, let me begin by saying that I incorporate all of my comments, all of my observations we have made previously as to documentary evidence of the sort that has been presented here today, and therefore I will not go into in any great detail as to which documents should be excluded, because we have talked about the sorts of categories such as articles, government documents, generated documents, and what have you. But for illustrative purposes, with respect to the prosecution's documents, I would like to make reference to 2 in particular. One is it's D199/26.2.132, which has also been numbered as E3/2666. And this is the document that was drafted by a Mr. Jean-Louis Toffin, the ambassador of France to Thailand. And yesterday there was a lengthy presentation by the prosecution reading copious amounts of the document that was produced by the ambassador, wherein the ambassador recounts what a General Buon had indicated to him, and furthermore, the ambassador's opinion and insight as to the legitimacy, or the veracity, I should say, of the information that was provided to him by the general. So, and this was produced back in 23 June 1975. So we have a hearsay from hearsay, and now it's being introduced in a very dramatic manner, well read, perfectly accenting the portions that the prosecution wishes to bring to the trial chamber's attention. to what extent can the defense test the validity of this information when neither the general nor the ambassador will be coming in to give evidence, or at least I'm unaware of. And to that extent, we would respectfully request that these sorts of documents should not be considered by the trial chamber. They may be informative in some respects, but where there's no ability to test the validity, where the accused do not have the ability to confront the witnesses, where you have a document that contains hearsay, and the document itself is hearsay itself, the trial chamber should simply disregard it, however well read into the record by the prosecution. And I fully understand the procedure, and so I will end up by saying that should you be tempted to rely on this document and documents such as this one, to do so with great circumspection and to certainly not give it any weight unless it can be independently verified through other witnesses that do in fact come in and give evidence. The second piece of evidence, or documentary evidence, that I wish to comment on is actually the video that we saw yesterday. I think it's the 12th played, video number 12, and that is E186.1R. And if I am wrong, we hope the prosecution will correct us. I believe it began at 01.22-20.58. First of all, let me begin by complimenting the videographer for making the video. If anything, perhaps it's a lesson to the Office of the Core Investigative Judges and perhaps even the prosecution on how an investigation should actually be done, going out there, meeting with the witnesses, getting testimony, which begs the question, why hasn't that been done? And instead, why is the prosecution relying on videos by a video maker and presenting it as evidence and asking you, Your Honors, to accept that as evidence? Would it not be more prudent to bring in any witnesses who are actually either seen in the video or who may be available to come and give evidence and to be subject to cross-examination and confrontation, as all of the accused are entitled to, a right guaranteed by the Cambodian Constitution. So again, when considering this sort of documentary evidence, we would ask that you disregard it unless the witnesses come in, the witnesses who are appearing in the video, not the video maker, but the witnesses who actually have something to say can come in, be put under oath, and provide evidence. The alternative, of course, if you are tempted to simply accept that, as it would appear the prosecution has and the OCIJ has, since it doesn't appear that the OCIJ actually did any real credible investigation of its own, other than relying on such footage as this and DC cam investigation, then, of course, give little or no weight to it unless independently verified. And lastly, just briefly to comment on the civil party statements that were read into the record, suffice it to say that these are unsworn statements. Unless they come in to give evidence, they should be taken for what they are worth and to be given the appropriate weight as provided by the rules of procedure. Thank you. I have nothing further to add, and we have no documentary evidence to present at this point in time. Thank you very much, Your Honors.
The President, thank you. Now I hand over to the Counsel for Mr. Kiew Sampon. You may proceed.
Merci, Monsieur le Président. Je ne serai pas très longue. J'ai effectivement des observations sur les documents présentés par les copropriétaires.
Excuse me, I won't take up too much of your time. I have some comments presented by the prosecution and the civil parties, but at this initial stage I would like to rectify a mistake that came into the record to which my attention was drawn. And I have to apologize to the interpreters because I'm aware that the mistakes that I intend to correct here are due to the fact on Wednesday the 22nd of January I was speaking a little too fast, so it'll teach me to make an effort to speak slightly slower, and so that my statement of that 22nd of January should be clear for all rather than just Judge Laverne. I will make it quite clear what I said in French to the hearing of the 22nd of January. Slightly after 3:38 and 40 seconds. I'm looking at the draft version here in French, where I referred to Memo E170 and the fact that paragraph 4 of that memo says that there is no time planned for the parties to reply to the documents presented. And what I said in French about the Kiew Sampon team's position was that is how we always envisaged these document hearings, and that is why so far we have held the position that we have. And it continues. On the other hand, I have to point out that I had indicated this morning that we have fully understood that the comments were open for the accused themselves, but not for their defense lawyers. And that is why I wanted to add this information in order to lend understanding to the confusion so far. But that is what was said in the memo, so do allow us to apologize for paying too much attention to it. Now, I believe I understood in English it seemed to be saying that we hadn't read the Chamber's memo and we hadn't paid attention to it. Quite the contrary. It's important. What we understood in the memo was understood, in fact, I think, by all of the parties, taking account of the email exchanges with the senior legal officer on the subject. And once again, I'm being asked to slow down. It's a very bad habit I have here, but I must say that in this hearing of 22nd of January 2013, at 3:41, answering Judge Laverne on the present position of the Chamber, taking account of the decision that handed down by Judge Cartwright, I answered, of course. Today it's much clearer now, and it is completely different to what we read in the memo. I wanted for this version to be clear for the entire procedure in English and in French. And having made this remark, I'd like to come to my comments on the documents presented by the co-prosecutors and the civil party lead co-lawyers. My first point is that clearly the remarks made by my colleague Counsel Carnavas are entirely correct about the documents he was talking about, and we would endorse those comments. I refer to your decision 97/7, in which you refer to the weight that you would give to this kind of document when they are documents emanating from individuals who are not going to come and testify, and I would ask you to apply your decisions in that area. Second, I would point out that in his presentation, the prosecutor very skillfully, and we salute the work that was done, sometimes at points where he was quoting certain documents, inserted some video extracts, and I would like to make a comment on that procedure, which, if it is certainly very skillful and requires a lot of work, it does also pose a problem in the way it comes across in probative terms, because the prosecutor quoted documents with dates and, if I understood correctly, was illustrating his comments with video extracts. But again, these were video extracts where we don't know exactly where and when they were filmed, and where the connection with what is said in the statements is not always entirely clear. And if such a montage can be accepted in a documentary, it may be okay. But as a way of presenting something in a court of law, it's not acceptable, because you are inserting elements that are subjective ones, depending on who was doing the filming, and which refer to certain circumstances that prevailed when the video was being shot, and which are not necessarily available to all of the parties. For example, when you see bodies stretched across the ground in these pictures and you don't know the circumstances in which they were killed, and I do acknowledge the prosecutor's wish not to put the commentary on a number of these videos, because it might have been not impartial, but you don't know the date, you don't know the circumstances, you don't know who is lying there dead on the ground, and the impression is therefore given that these videos are directly connected to what was being read out. To me, this is problematic when we discuss it in probative terms. We have discussed these kinds of issues, and we do need to draw attention to this, as it was done by the co-prosecutors. The matter of the videos was also brought up by my learned colleague, Mr. Carnavas, and in one particular video, A Day in Portray by Tet Sambat, which was broadcast on the 23rd of January, or rather shown here on the 23rd of January in the afternoon. Again, this raises the issue of the statements made by people who are not going to come and testify here, and the question of adversarial procedures and respect for them, even if the journalistic work is of a very high quality. Nevertheless, you cannot ask questions in a courtroom on some of the contents, and there are matters that can be described as speculative. For example, yesterday at 15:42, we saw a young man who supposed that there may well have been rapes. And there I think we're really bordering the limits of the utility of such documents in a court of law. Because, as I said, if there is not a witness who's going to come into these hearings so as to be confronted by the different parties questioning, then these kind of documentary pieces of evidence have to be very, very carefully and cautiously treated. If you have a young man who is talking about his memories of when he was age 10 or 12, then problems do arise when you are conducting a criminal trial. That's what I wanted to say today on that particular subject, and I reserve the right to make any further comments that my client, who is absent today, may wish to add. And I once again apologize to those in the interpretation booths for occasionally speaking too fast. Thank you very much.
The President, thank you. I hand over to the prosecutor. You may proceed.
Mr. President, just a few points, please. I'd first like to thank my counsel from the other side of the court for the defence for describing the presentation as skillful and well delivered. Certainly, as far as the clips were concerned, I felt they weren't Steven Spielberg, but they would nevertheless inform the Chamber. I agree entirely with the representations or submissions that are made regarding admissibility and weight being entirely different. All this material is admissible. As Her Honour Judge Cartwright made plain yesterday, admissibility and weight are two entirely different legal concepts. And we know that the trial chamber will take this material in terms of assessing its weight. And so that means with the extract from the Brigadier, we appreciate, of course, that you will look to other evidence in terms of whether that is useful and whether it's corroborated by any other accounts. If I can pick up on one point raised by my learned friend, Mr. Michael Carnavas, who poses the question, will there be evidence to corroborate evidence that was shown in the presentation? And to give but one example, the trial chamber may have well in mind an image that is shown on one of the video clips of a group of Lon Nol civil servants stood in a courtyard on the 17th of April. That was a photograph taken by Al Rokov. It may be in due course, if Al Rokov appears as a witness, he may be able to tell the court what happened to those people. Thank you.
The President, the National Lead Co-Lawyer for the Civil Party, you may proceed. Counsel Pich-Ong. Good afternoon, Mr. President, and good afternoon, Your Honours, and good afternoon to everyone. I have 2 points to make in relation to the observation by Mr. Michael Carnavas, the Defence Counsel for Mr. Ieng Sary. He mentioned about the professionalism of the medical doctor, and I would like probably to ask the court to clarify the qualification of the doctor as well as his professional experience. I don't know whether or not the remarks by the defense team for Mr. Ieng Sary is appropriate in relation to the qualification of the assigned doctor. My second point, the point raised by counsel for Ieng Sary as well as for and counsel for Khieu Samphan, they mentioned that in the series of videos played contain some of the witnesses, and they consider those videos that they do not have any probative values if the witnesses were not summoned to testify in person in court. I would like to make my observation on this particular point. Of course, there should be a possibility for the defense counsel to request the summon of these potential witnesses to testify in court. If the accused, the counsel for the accused wishes to ask, and if the defense counsel wants some of the civil parties to come to testify in this court, of course, those civil parties will be happy to testify in this court. And over to my international colleagues to add to this.
Oui, je voudrais simplement.
Just a few further words to respond to the defence, and particularly the defence of Yang Sari, concerning the documents that were presented by the civil parties. Firstly, generally speaking, I'm wondering if there is a way or some form of rule or discipline in this court for us not to come systematically to debates that have already taken place on points that have already been debated, particularly where decisions have already been made. I am referring to civil party oaths, and we have exchanged memoranda on the subject, and the Chamber has already given a decision on these oaths. I would also point out that it is quite incorrect to suggest that because the civil parties may not take oaths, what they say does not have probative value. It's not because they do not take an oath that those near 4,000 people are lying, or at least have somewhat exaggerated imaginative powers. And after you listen to witnesses who do take oaths and civil parties who do not, after listening to both for quite a few weeks, I think you can have a certain idea about the honesty of the civil parties who do not take oaths. I would also point out that the internal rules, contrary to what my learned colleague may have thought, do not say that you have to give appropriate weight to statements by civil parties because they do not take oaths. On the contrary, the fact that civil parties don't take oaths is simply a part of civil law as it is practiced here, and I'm sorry to have to repeat this fact. I regret that we have to deal with hearsay about hearsay, but let me simply say that with civil parties you have the statements by people who were there between 75 and 79, who saw and who heard and who lived situations very directly, and it's certainly not a matter of hearsay about hearsay. Thank you, Mr. President.
The President, I note Councillor Canavas is on his feet. You may proceed.
Thank you, Mr. President. With respect to the doctor, we would invite the trial chamber to invite the doctor to come and give evidence as to his qualifications, if that is a question that troubles the civil party lawyer. With respect to the one comment made by the national lead lawyer for the civil parties, that the defense ought to call these witnesses, including the civil parties. Let me remind the gentleman that the defense does not have a burden of proof. This is sort of a universal principle that is applied everywhere, including in Cambodia and before this tribunal. It is not up to us to call witnesses. If, however, the prosecution wishes or the civil party wishes to rely on a particular statement, it is our position that the better practice, recognizing the procedure, the better practice is to have the witness come and give evidence and to be subjected to cross-examination. We are not suggesting that nothing comes in that has been taken as a statement, but we do recognize and we do submit that those statements do have limitations when it comes to the probative value. And I take the point made by the prosecutor that there is a vast difference between admissibility and the probative value to be given to a particular piece of evidence, especially since we're dealing with professional judges. With respect to the civil parties, first of all, we are entitled to make comments. We were asked to make comments. I don't see why they get all worked up when we are merely doing our job. I think it is a fact of life, and it is a fact to say that when someone provides evidence that is not under oath, it automatically should have less probative value because it is not under oath. The reason we put witnesses under oath is because then they are subject to the penalty should they lie under oath. It is called perjury. An accused does not take an oath in the civil law system as opposed to the common law system because an accused in the civil party is entitled to defend himself or herself by any means, which means they can lie with impunity because it is up to the judges to find the material truth. It is not recommended, but in essence, that's what it is. And we have never suggested, and let me be very clear to the madam, that we have never suggested that the civil parties are lying. We have never suggested that their statements have no value. But we are pointing a fact, that one, those statements were provided without having taken an oath. And two, when the civil party is not here to be questioned at least, that even puts the defense at an even greater disadvantage because their testimony cannot be challenged or cannot be examined. Be that as it may, let me be very, very clear on behalf of the Inquiry defense. We recognize the vital role of the civil parties. We recognize that they are entitled to give statements that are not under oath. And we do recognize that the trial chamber is perfectly permitted to consider their statements along with all other evidence and to provide the appropriate weight that those statements should be given. And I shall continue, as my colleague, Mr. Angodom, will continue, to make submissions when called upon to do so. Thank you.
President. In order to clarify the matter regarding the treating doctor of the accused at the detention facility, and as indicated repeatedly by the defense counsel for Mr. Ieng Sary, and the Chamber has actually ruled on a number of occasions, including in writing. And another matter in regards to the civil parties who are going to be testify before this chamber, and whether they would need to swear, and that matter has been also ruled. We are here practicing the civil law system, and based on the Code of the Criminal Procedure of the Kingdom of Cambodia, as well as the applicable internal rules of the ECCC. And in order to clarify the matter further, I'd like to hand the floor to Judge Cartwright to add more clarity to these matters. You may proceed, Judge Cartwright.
Thank you, President. Relating to the comments that Counsel for Ieng Sary made about his client's current state of health, the first issue is this, and I repeat what the trial chamber has ruled clearly on at least 2 occasions in the past. The treating doctor is to report directly to the trial chamber on any substantial changes in the health of any of the accused. It is unhelpful for medically unqualified staff or lawyers to press the treating doctor because he is clear that his report must be direct to the trial chamber. Finally, and because certainly my speaking colleagues did not understand the meaning of the word mendacious, that is an English word which means that the doctor is lying. That, of course, is an inappropriate statement to make in court, or anywhere for that matter. As to the discussion about whether or not civil parties should take the oath and the consequences of that, we have had this discussion on many occasions, and the Chamber is fully aware of the responsibilities that it has, and we do not wish to have this argument repeated ad nauseum or frequently, to omit the Latin. Now, President, I think there was one final matter about the scheduling for next week, which you were going to indicate, or would you wish me to indicate that now? Well, as to the scheduling for next week, we have given indications that, subject to the state of health of the accused Nguyen Chia, and to his willingness to waive his right to participate, we will be hearing the witness whose pseudonym was read out earlier on Monday. The indications that we have had are that Kyo Sampan will be discharged from hospital and will therefore be fit to continue to participate next week. We will return to the document hearing on Wednesday with the next part of the presentation by the prosecutors on the roles of the accused. And we will, of course, be adjourning tomorrow and, of course, next Friday, which is a national holiday. I hope that that is sufficiently clear for your purposes, President, and for the parties.
President, thank you, Judge Cartwright, for the clarification and for informing the parties and the general public in details regarding the issues that have been faced by the Chamber and that the Chambers have resolved, as well as the scheduling for next week hearing. The schedule for today's proceeding has come to a conclusion. The Chamber will adjourn today's proceeding now, and we will resume next Monday, that is the 28th of January 2013, commencing from 9 a.m. And depending on the health of the accused, and another accused who is being hospitalized at the hospital currently, whether he is willing to waive his direct presence, and that we would urge Nunchi's counsel to notify the Chamber as soon as possible or tomorrow regarding this matter and the scheduling for Monday next week. We will adjourn now, and security guards are instructed to take the accused Ian Seri back to the detention facility. The court is now adjourned.